welcome. I think we're a minute late, so apologies for that, maybe two. But we're delighted to have you all here today. I'm Ivy Barsky. I'm the director of the Lillian and Albert Small Capital Jewish Museum. Delighted to see all of you here. This is the first program like this that we've had. We've had some programs, but we haven't really had a panel yet. We haven't really used this room in this way. So thank you for being our guinea pigs. And thank you for being here. And especially thanks to Lisa Del Sesto, who is responsible for this and all our programs. So welcome to tonight's event, the Post-RBG Court, a panel discussion with Dahlia Lithwick, Roman Martinez, Jeffrey Rosen, moderated by Justin Lamb. Before we begin, I want to acknowledge generous sponsors who made this evening possible. Thanks to PNC, the presenting sponsor for our special exhibition, Notorious RBG, The Life and Times of Ruth Bader Ginsburg, organized by the Skirball Cultural Center in LA. It's on our third floor. It'll be here through the end of November. Support for this program is also provided in part by Humanities DC. Tonight's conversation will give us and of course we wrote the introduction yesterday, so today's like a whole different story, right? But tonight's conversation will give us an inside look at this season's pending cases and the climate of the Supreme Court, and highlight why the court's docket matters to each of us. Perhaps we'll hear some insights into what Justice Ginsburg would think about any of them. The panel discussion will be followed by a book signing with Dahlia and Jeffrey. Copies of their books can be purchased from our Gewertz museum shop. I will tell you that if you are not yet a member, if you become a member, you have a discount at the shop and at future programs, so we'd encourage you to do that. Raven, raise your hand, our membership coordinator, and anyone at the front desk would be happy to take care of that for you. It's now my pleasure to introduce our moderator for the evening, Justin Lim, who in turn will introduce our distinguished panel. Justin is a current judicial law clerk and co-chair of the board of directors of the Appellate Project, a nonprofit that empowers law students of color to become the next generation of lawyers and judges in our nation's highest courts. Justin was part of the inaugural mentorship class of the Appellate Project in 2021 when he graduated from the University of California, Berkeley, with a JD and Master of Public Policy. I'm going to turn it over to Justin, and again, thank you all for being here.
Thank you so much, Ivy, and thank you everyone for making it out tonight. Just a few words about the Appellate Project before I introduce tonight's panel. As some of you might know, as a lot of you probably know by being here at this event, the Supreme Court and courts of appeals at the federal and state level throughout the country really have the power to shape laws on issues that affect our everyday lives, issues ranging from policing to education to healthcare to voting and so much more. Yet, despite that impact, nearly 30% of law students are law students of color, yet very few of those students end up in appellate practice. And so the Appellate Project helps law students to explore the appellate profession through programming that includes a mentorship program. I can say that program certainly changed the course of my career and is continuing to change the courses of careers for law students around the country. So we are just so grateful to the Capital Jewish Museum for thinking of us and incorporating us in tonight's event. So with that, let me introduce our panel. Dahlia Lithwick is senior editor at Slate, and in that capacity has been writing their Supreme Court dispatches and jurisprudence columns since 1999. Her work has appeared in the New York Times, Harper's, the New Yorker, the Washington Post, the New Republic, and Commentary, among other places. She is host of Amicus, Slate's award-winning bi-weekly podcast about the law and the Supreme Court, and her 2022 book, Lady Justice, was a New York Times bestseller. Roman Martinez is a former deputy managing partner of the Washington, D.C. office of Latham Watkins, LLP. He focuses primarily on appeals in the Supreme Court and federal and state courts of appeals, and has argued 13 cases before the Supreme Court. He previously served as an assistant to the Solicitor General at the U.S. Department of Justice, as a law clerk to Chief Justice Roberts and then Judge Brett Kavanaugh, and in various foreign policy roles at the White House, Coalition Provisional Authority, and the U.S. Department of Defense. And last but not least, Jeffrey Rosen is the president and CEO of the National Constitution Center, America's leading platform for nonpartisan constitutional education and debate. Rosen hosts the center's weekly We the People podcast and teaches Constitution 101 classes for learners of all ages. He is a professor at the George Washington University Law School, contributing editor of The Atlantic, was previously the legal affairs editor of The New Republic and a staff writer for The New Yorker, and has authored 7 books, including the New York Times bestseller Conversations with RBG, Justice Ruth Bader Ginsburg on Life, Love, Liberty, and Law. So, the way tonight's conversation will work is that I'll go through a series of questions that touch on 3 major themes. We'll talk a little bit about the Supreme Court, including its cases and its climate, the court and courts as institutions, and lastly, but not least, how we as citizens might continue to engage with courts, whether you're a lawyer or not. We'll have a few minutes for audience Q&A, and I'll reserve a bit of time at the end for the panelists to share some concluding thoughts. So first, I was prepared to ask a question about what happens to courts during a government shutdown. I'm very glad to report that I don't have to ask that exact question, but while it's all on our minds, can I ask one of the panelists if one of you would like to volunteer? Can one of you just explain to us what happens to the Supreme Court and courts during a shutdown? And have any of the previous shutdowns overlapped your roles either in journalism or in advocacy?
I'm happy to jump in. So my understanding, because I researched this today, is that the judicial system generally has about 2 weeks worth of funding through fees and other sort of pockets of money that they have. So if there had been a shutdown that started, the courts generally across the country would be able to stay open for 2 weeks, which is good, I suppose. Although if you have anything pressing happening more than 2 weeks from now, that'd be a problem. The Supreme Court, I think, would have stayed open. It would have been deemed essential enough to stay open. I don't recall, I think I was in the Solicitor General's office when there was a government shutdown last time. I don't remember it affecting me. I think there were a lot of people in DOJ who were deemed essential enough, and somehow I snuck in, so that didn't affect me. My only other government shutdown experience was Snowmageddon. Do you all remember that? Snowmageddon came when I had the pleasure of clerking for Chief Justice Roberts, and it must have been in the middle of February or late January, and the good news was I had just become engaged to my lovely bride sitting right there, and it was a very good occasion to stay home and do some wedding planning and audition. I think we auditioned bands. Those days they sent CDs, and you put the CD in and listen to music. So it was a very productive shutdown for me due to snow. I'm not sure what it would be like if we were in a shutdown situation due to Congress. So hopefully we won't get into that situation anytime soon.
Anything to add, Jeffrey or Dahlia?
I would add the footnote that I don't know if it was Snowmageddon, but there's an amazing, Jeff will know that whether this is a apocryphal or true, story of Justice Ginsburg in the midst of some harrowing snowstorm being carried by her security detail over snowbanks at the entrance to the court. But just the idea of like tiny little Ruth Bader Ginsburg being like ferried around through the snow is one of those like, I don't even care if it's true, because I think it's true.
Well, we'll cross our fingers for no shutdowns and hopefully no Snowmageddons this upcoming fall and winter. Now for one of the conversations maybe you all were expecting more. So as some of you know, the Supreme Court term begins every first Monday, so happy first Tuesday. Sorry, we couldn't make the dates work. So the Supreme Court gets about 5,000 to 7,000 petitions each year rather, and only hears about 80 cases each term. As of Friday, I believe, correct me if I'm wrong, that there are 34 cases currently calendared for the 23-24 term. So we'll just go down the row. What's a case that you're paying attention to and a broader issue that it represents?
You want to start with me? There's one big theme, which is the sort of attacks on the administrative state. Today's CFPB argument was one of them. There's a case that is going to sort of see whether Chevron deference continues to be a thing, which is a longstanding rule from 1984 that one refers to an agency's construction of their own rules. But those aren't the cases I want to talk about. I think the one that I am watching most anxiously is Rahimi, which is a follow-on to Bruin, the gun case from 2 terms ago. And this is essentially, having kind of found an individual right to bear arms under the Second Amendment in Heller, and then expanded that in Bruin to use this test that essentially says if there was no analogous restriction on guns, either at the time of the framing or the ratification of the 14th Amendment, then the gun regulation kind of has to fall. And that was the test that was introduced in Bruin. It has led to results around the country from judges who both unhappily and happily have applied that test to say things like, well, the law that says you can't saw the serial number off a gun has no analog historically, so I guess it falls because there were no serial numbers. So Rahimi kind of puts that to the test, and I know we're going to talk a lot about the Fifth Circuit because this is one of a bucket of cases that come up from that particular federal appeals court, but Rahimi really puts to the test this question of whether somebody, in this case, Zaki Rahimi, who is adjudicated dangerous to his partner, and is, the facts of the case are quite horrifying in terms of what the alleged domestic violence that he engaged in looked like, but the bottom line is the federal statute that says if you have been adjudicated to be subject to a domestic violence order and you use a gun, you go to jail. And the question really becomes, at the most basic level, given that there was no such thing as domestic violence at the founding, and certainly no such thing as being civilly adjudicated to be a danger to your partner, do all such laws fall post-Bruin? And to me, I think it's an interesting, we'll probably talk about this too, it's sort of, I put it in the bucket of, dog catches car, where you get, a sort of gun rights movement that gets virtually everything it wants after Heller and Bruin, and then rather than take the win, asks for more. And this is, I don't need to belabor the fact that this is the Supreme Court that is sitting in the midst of, more lethal mass shootings every year, a generation of kids who are growing up subject to, school lockdowns. So for the court to sort of have to grapple with the tension between a very, very pure historical analysis of Second Amendment regulations in the face of just the absolute fact. I mean, we know that you are 5 times more likely to be killed if you're in a domestic violence relationship and your partner has a gun. So that collision between how the court wants to think about gun regulation under the sort of rubric of people will die, I think is a case to watch because it really signals, in my view, how much the court wants to be kind of jammed by the courts below.
Completely agree with Dahlia that the cases to watch are the ones involving the future of the administrative state on the one hand and this Second Amendment case on the other. And both raise a crucial question about how far the conservative judicial revolution is going to go, and also important differences among the conservative justices. So there are 2 camps that are emerging. On the one hand, the 3 textualists, Justices Gorsuch, Alito, and Thomas, and on the other hand, the 3 justices who care more about text, history, and tradition, which are Chief Justice Roberts and Justice Barrett and Justice Kavanaugh. And that tension was seen most dramatically, just to understand the stakes. Last term in the election case, remember, where the claim was that state courts have no role to play reviewing election results, and if a state legislature wanted, in a presidential election, it could hand the election to Trump rather than Biden and not have that reviewed by state courts. It was an unusual claim, and the court rejected it by a 6-3 majority, with the 3 text, history, and tradition people joining the liberals saying that's ridiculous. At the time of the framing, everyone stood up and said, of course, courts are going to review all laws, including election results, and Marbury versus Madison said so, and here's lots of precedent, and text, history, and tradition clearly make us reject the claim. And the 3 textualists said, no, legislature means legislature, and if you just read that word out of context, you have to say legislature can't mean courts, and therefore we can reach a result that might not have been intended by the framers, but would have dramatic consequences. That same split is playing out in the decision about the future of the administrative state and the Second Amendment. So the administrative state sounds wonky or whatever, but this was the whole point of the conservative judicial revolution when Ronald Reagan in 1980 said he wanted to appoint originalist justices who would care about text, history, and tradition. The goal was to roll back the excesses of the New Deal and the Great Society, in particular, alphabet soup agencies like the Fed and the EPA and other agencies that the claim was had represented too much executive power, unconstitutionally delegated from Congress, and the claim was that the court had to resurrect restrictions on that delegation that had been dormant since the New Deal. And this is the term that those chickens are coming home to roost. And just today, the court heard this case about the constitutionality of the Consumer Financial Protection Board, and then it's going to decide whether Chevron deference, which means should judges defer to administrative agencies, should be reconsidered, and more. Once again, we may see a split between the more textualist justices who really do want to strike down much of the administrative state, even though these limitations, as it happens, are not written down in the text, but they include principles like non-delegation and clear statements required by Congress that are implicit in the principle of separation of powers, and the more pragmatic justices, like Justices Kavanaugh and Roberts, who don't want to go that far, and their questions this morning suggested that they may not go so far. Rahimi is so fascinating for the reasons Dahlia said, and not to get too technical here, but it was a great confusion to many of the lower courts and litigants when Justice Thomas, in the Bruin case, said that judges should look not only at the text or original understanding of the Second Amendment when it was ratified or incorporated against the states at the time of the Civil War, but should look at historical traditions throughout American history, and you need an analog for a regulation historically before you can embrace it. And in addition to being confusing doctrinally, that was never a promise of originalism, it created this really confusing need for lower court judges to get historical experts on the meaning of crossbows in the Statute of Northumberland in 1363. And also, as Dahlia said, how can you have a historic analog for domestic violence regulations when domestic violence was sanctioned by common law rather than prohibited? It just kind of came out of nowhere, and it may be the case that at least the more pragmatic justices, if not the more textualist ones, will rein this in and say that you can enforce the Second Amendment right without finding historical analog. I'll just end by saying this is a vigorous intellectual and substantive debate among conservatives about when to look to text, history, and tradition, when history can trump text, and how exactly to do originalism. And if you all get excited about the Constitution, as I hope you will from this fascinating discussion in every way, then familiarize yourself with these debates, read the opinions, and make up your own minds about who's right.
Well, I agree with both my fellow panelists that the gun case and the administrative law cases are super interesting. I think another area that is extremely interesting is the First Amendment on the docket this year. And in particular, there are a couple cases that are implicating the First Amendment and how it sort of works in a world in which the public square is really quite different from what it used to be. It used to be that when we worried about free speech, you were worried about just the government directly regulating what you wanted to say. And so if you're out there in the park and you're on your soapbox giving your speech, you're worried about a police officer or someone coming down telling you you can't give that speech. But today, so much of the public discourse in our country takes place over the internet, and it's mediated through social media companies and internet platforms, which by hosting that speech have the ability through their algorithms and through their content decisions to affect and in some ways control or amplify or de-amplify or in some cases block what speakers are allowed to say on their platforms. And there's a question about how do we think about the role of the social media companies in the middle of this sort of formerly just sort of government speaker sort of situation, and what does the First Amendment have to say about that? And so the court has taken a couple of cases that involve very similar laws, one passed by Texas, one passed by Florida. These laws were passed sort of driven by conservative concerns that some of the social media companies are moderating their content in a way to discriminate against conservative viewpoints. And they basically, in different ways, place restrictions on what the social media companies can do with respect to content moderation. And in both cases, an industry group representing sort of the social media companies is basically saying, wait a second, we have our own First Amendment rights. We are speakers. We have the right to control what kind of viewpoints are put on our platforms. And if we want to moderate content, that's something that the Constitution allows us to do. And it's kind of interesting because these laws are sort of very similar. They came out in these two states. In one of the, with respect to the Texas law, the Fifth Circuit, with a Trump-appointed judge, said that the media companies were wrong and that the law that Texas passed was right. In the 11th Circuit, examining the Florida law, a Trump-appointed judge, also a conservative, said the exact opposite. And so now the court has taken both these cases and is going to be looking at this very interesting question of sort of how the First Amendment operates. Just one quick word on another case that the court might take and that you all may have heard about because it's been in the papers recently and on the internet recently. There's a lawsuit, I think it's called the Murphy case now, where various speakers were claiming that the Biden administration were essentially getting social media companies to censor their content. So people who were offering dissonant views about the origins of COVID, I think other examples in the briefs are Hunter Biden's laptop, Black Lives Matter, across a host of topics, are concerned that the government, in this case not the conservative states of Florida or Texas, but a left of center administration is basically picking up the phone and telling social media companies that this is disinformation, you need to take these people down, you need to de-amplify their content. And I don't know whether the facts of that are right or wrong, but there's the court ruled the Fifth Circuit ruled that these claims had validity, and that the government should not be in the business of sort of dictating to social media companies what people can say on their platforms, and that is an infringement of the speaker's rights. And so you have a similar sort of issue where you have to think about the relationship between the government, the social media intermediaries, and then the speakers, and how the First Amendment applies to this whole new world of technology. So super hard, very interesting issues, and I think unlike some of the other cases that have been mentioned, these are issues that might not track sort of ordinary ideological divisions, which sometimes makes for the most interesting cases at the court.
Thank you. Yeah, so we've definitely talked about a number of contentious issues, everything from the Second Amendment to the administrative state to First Amendment issues. Roman, I'm going to pick on you for a second and actually explore the flip side of that question. So last term, you argued a case called Perez versus Sturgis Public Schools. That was a case where the Supreme Court expanded rights for students with disabilities in a 9-0 vote. Would you say from that and your experiences over the years, would you say that there is a set of sort of less politicized or more common ground issues amongst the 9 justices, or did Perez and do those cases feel like outliers, especially in light of the docket that we just talked about?
Yeah, so a general comment and then a little bit on Perez. I think that the public, people who are not Supreme Court nerds, like me and Dahlia and Jeff, the public, I think, experiences the court mainly through a small number of very high-profile decisions, and that is, I think, distorts the picture of what the court's work is every year. As Justin was saying, sometimes you get somewhere between 55 and 75 decisions a year, and most of those don't get a lot of attention. And if you look at those decisions, you might learn something that's sort of interesting and maybe a little counterintuitive, which is that the vast majority of them, the court takes these cases because they're hard and divisive and the lower courts are confused as to what the law is. But in the vast majority of the cases, they end up getting decided either unanimously or 8-1. So last year, I think 58% of the cases were 9-0 or 8-1. And the number of cases that were decided along the lines of the 6-3 sort of conservative liberal split that we're all used to talking about there were just 5 cases decided that way, so 9% of the docket. Now, of course, those 6-3 cases are sort of overrepresented when you think about sort of the hottest button, most politically divisive issues. But I think it's important to keep in mind that this is a relatively small share of the docket. And even as to the important questions, if you look at the SCOTUS blog website, which has been a great website over the years for covering the court, they identified last year what they thought were the 11 most important decisions. If you look at those 11, plus you add in a decision on the shadow docket, which we'll talk about, that involved abortion and an abortion pill. If you think of those as the 12 most important decisions from last year, the liberal side of the court ended up being in the majority in 9 of those 12 cases. And so there's a little bit more nuance here. Not every case is the sort of divisive 6-3. Very quickly on Perez, it's interesting. I like, Justin, how you make it sound like an easy case, not political. I will tell you, it's an interesting case. It's a civil rights case. We represented a deaf child who was discriminated against in his public schools. When we were bringing the case, and I've worked on a couple of these discrimination cases, the sort of progressive interest groups in this area were very nervous about us taking the case to the court, but we always felt that we were going to get a fair hearing at the court because we had what we thought was the best textual argument. And all the lower courts had actually rejected our position in this case. But we went to the court, we got a very fair hearing. Justice Gorsuch, one of our textualists, wrote the opinion for 9 justices based on the text in support of a civil rights plaintiff, and we were very proud of that result.
Thank you. Now let's dig into that nuance and the term you just used, shadow docket. And for that, I'm going to turn to Dahlia. So, separate from the cases the Supreme Court takes, there's a whole world of procedural docket. You've done some conversations about this on your podcast, Amicus. What is the shadow docket? Why should and how can non-lawyers engage with that? And do you think the media should be having more conversations about this shadow docket?
So I think part of what happens in the conversation around the shadow docket is that it sounds really nefarious. And so when Justice Alito goes to Notre Dame and gives a speech that initially is closed to the press, but then it's open to the press, what he says, which is not incorrect, is that sounds so bad. The term shadow docket was actually coined by a pretty conservative law professor, Will Bode, and it wasn't meant to be a critique. It was the name for the emergency docket, which the court has had forever, right? That's how you do executions. That's the Rosenbergs, that's death penalty cases. There's been, throughout history, the need for a docket where something is exigent, you don't have time for briefing and oral arguments, the court has to make a decision. That's the shadow docket. The critique, and probably I think the best book on this is our friend Steve Vladeck at University of Texas has an amazing book that came out this spring about the shadow docket, and I think his critique is twofold. One, it began to be used, particularly in the Trump administration, as a way to rocket a case in an emergency posture up to the US Supreme Court without the necessary briefing and oral argument and sort of developing of the case. It was a way, and this was just something where the Justice Department would get an outcome they didn't like and sort of rocket it to the Supreme Court. The other part of the critique is that a lot of really important doctrine got made on the shadow docket. And so you all may recall 2 terms ago, SB 8, that was the Texas quote-unquote vigilante bill, that said that anybody could sue anyone who aided or abetted an abortion, and they could civilly sue them. That happened long before Dobbs, right? Long before Dobbs was even argued, which ultimately overturned Roe v. Wade, on the shadow docket. And the court just blessed it and said in a very inscrutable back-of-the-napkin order, like, hands are tied, this goes into law. So by the time Dobbs was being argued at the US Supreme Court, effectively for 10% of the childbearing population of the United States, Roe was over. So the critique is, and we really saw this in the COVID cases, where the various restrictions on attendance at religious services that happened in COVID get decided on the shadow docket, again, without extensive briefing, without argument, without, the thing that the court is meant to do, which is show your work. None of that happens, and then we get the court relying on shadow docket orders to say, we already decided this in this thing that we wrote, like with lemon juice that disappeared in invisible ink, but if you hold it up to the light, you can figure out what the rule is. And so I think the critique, I would say, wherever you land on that, first of all, we've seen, and Steve Vladeck pointed out, that the use of the emergency docket since folks started complaining about it has ramped way, way, way down. We're seeing much less happening, sort of in the dark of night, at midnight, unsigned. Some of these opinions we didn't know who wrote them, and we didn't know what the vote was. Did Justice Barrett vote with, we don't know, in these per curiam orders. And so I think that this, to me, is a sort of larger scale critique, and the answer to the question of why we should pay attention is that a lot of people who are watching, whether it's the ethics stuff that's going on in the court, the failure to recuse, GlacierMartini.com that has really kind of suffused the conversation about the doctrine in the last couple of years. And I think it all comes under the rubric of be transparent. If we give you Article 3 life tenure, and we essentially say that you have, post-Marbury v. Madison, virtually uncheckable power, then the one thing you give us in return is absolute transparency. And so I think the critique of the shadow docket, the critique of the Supreme Court's lack of ethics rules that apply to themselves, the critique of the role of Leonard Leo and the Federalist Society in teeing up cases that come to the court, all of that, I think I see that as sort of subsumed into this question of show your work. And if we know what your work is, because you've been open, then we are much less apt to do the thing that the justices then go and give speeches about, which is we hate the press. So the press, I think, is now involved in a deep way in a conversation about the Supreme Court and public perception and these plummeting approval ratings, only because I think this was the technical term of art is like self-face punch, where the Supreme Court has engaged in a bunch of behaviors that make it less than transparent at exactly the moment that is arrogating to itself an immense amount of power to decide, right? Last term was all about arrogating the power to decide. And if you are going to do both of those things, then I think you have to be very, very, very open to the fact that everything you do has to be perfect. And the shadow docket strikes, I think, a lot of us. Again, we need an emergency docket, but it is not a thing that you rely on because you want to do an order in the dark of night that has 3 sentences and no doctrine.
Roman, you want to
Yeah,
add to that?
so I totally agree with Dahlia on the importance of transparency, especially with respect to the shadow docket. I think, as Dahlia says, we need to have an emergency docket. The Supreme Court has to have an emergency docket because the lower courts have them. And people go and get relief from the lower courts sometimes, without full briefing or full trial. And if those are on issues that are important, they can and should go up. But I agree with Dahlia that it's important to be transparent. I think the court has sort of evolved a little bit in response to some of the discussion in terms of sometimes scheduling argument on some of these shadow docket cases that are particularly significant and issuing more written opinions. I think that's all positive. I do think that it also, the importance of this shadow docket has grown in part because of the way in which it's sort of a bunch of different trends coming together. You have presidents now who often are making large changes to law or to regulatory programs, essentially unilaterally. Sometimes with authorization, sometimes arguably without. But they're issuing proclamations and executive actions that are a big deal, and that maybe a long time ago one would have thought that that's something that Congress had to do. And then what's happening is, and this happened when I was in the Solicitor General's office during the Obama administration, and then happened during the Trump administration as well, is the president comes out with something big and bold and controversial, and someone goes either to Texas or California to sue, depending on where you're trying to choose your judge, your venue. And then oftentimes you'll get a judge and maybe an appellate court that issues an order blocking a major initiative of the president. And then you have a situation where the Supreme Court sort of put in the position where, very early in a case, maybe 2 weeks, 3 weeks after this major decision has been issued by the president, it's been put on hold by basically 1 or 3 judges. And the president can't implement that program anywhere. And so the Supreme Court, I think, has to have a mechanism for resolving those types of disputes. I think the people who've been in the Justice Department defending presidents of both parties, their general view is courts just shouldn't be issuing these what they call nationwide injunctions. They shouldn't be halting presidential programs across the board. And maybe, half the time we would agree with that view, and it's a president of a different party, and maybe we'd be more sympathetic to it the other half. But either way, it creates this systemic problem where there's a lot of pressure for the court to intervene, and it's probably appropriate for it to intervene in these circumstances. But as Dahlia says, and I totally agree, if it's going to do that, it should do that in as transparent a way as possible.
So we've talked about the news of the moment. I want to step back and play the RBG exhibit, and I promise we'll come back to the news. For folks who've gotten a chance to go upstairs, and I highly recommend you do at some point if you haven't already. It's a great exhibit. You might have seen one plaque about a 2009 case called Stafford versus Rick. And so in this case, Justice Ginsburg was the only woman on the court, and she managed to persuade her 8 fellow male colleagues to rule in favor of a 13-year-old girl who had been subject to a strip search at her school. And as the story goes, her 8 colleagues, they're about to vote the other way, and RBG shares his perspective because, in her words, they had never been a 13-year-old girl. And so I bring up that case because it's lauded as an example of white diversity, and this idea of having different perspectives in the room is so important, especially from folks who have been traditionally underrepresented, in many cases, historically excluded from the practice of law. Now, when it comes to race, the court has issued a series of decisions that enforce this notion of color blindness. Most recently, of course, the affirmative action case from the last term, and there's certainly communities across the country that experience some of the effects and the harmful effects of that notion. Now that we're in this term, what can we expect from the court when it comes to issues of race consciousness? And Jeffrey, maybe I'll start with you, and then anyone else can jump in.
Well, the great affirmative action case from last year has not yet yielded a follow-up at the court. There are issues bubbling up about the degree to which Thomas Jefferson High School can eliminate its test in an effort to bring up the number of racial minorities, which the court may or may not hear this term, and more broadly, whether private employees and employers can be race conscious, and all of those crucial questions will play themselves out. All of these race questions evoke a quotation that's in the RBG exhibit that I know you wanted to discuss, and that was Justice Ginsburg's famously saying that when it came to protecting rights, the court should be moved not by the passions of the moment, but by the sensibility of the hour, or if I've got a version of that right. And it was really a remarkable reminder of her combination of a crusading devotion to creating a more embracive constitution, as she so beautifully put it. And by embracive, she meant a constitution that embraces the left out people, not just grudgingly, but with open arms. And at the same time, a deep sensitivity to the court's institutional limitations and its limited role in American society. And she got that quote, as those of you who've seen the movie know, from her law professor, Paul Freund, who was a great scholar at Harvard. And he was a advocate of Burkean traditionalism and of measured motions and of the court taking one step at a time. And his great mentor was Felix Frankfurter, who basically thought that the court had erred terribly during the New Deal when it struck down the administrative state before FDR got up and running, and that judges, learning from that lesson should always be sure to take measured motions, not to move too fast, not to put on the brakes too quickly or the accelerator too quickly, but always to nudge rather than lead or stop. And Justice Ginsburg was deeply moved by that in her criticisms of Roe v. Wade. Remember when Roe came down, she thought that it went too far in prescribing abortion regulations for all terms of pregnancy and for the whole nation, and she thought the court should simply have struck down the extreme Texas law at issue in the case, which had no exceptions for rape or incest, and made clear that was unconstitutional, but left the other questions about late-term pregnancy to be settled by the political process, which she thought was on the verge of liberalizing. She believed that by moving too quickly, the court mobilized a backlash in the anti-choice movement and set back the cause of women's equality, which she thought should have been rooted in equal protection rather than privacy. She was fiercely committed to upholding the core of Roe. She believed that it would have been upheld as long as Chief Justice Roberts remained on the court. Her dying wish, as you will recall, she said, is my most fervent wish that I not be replaced until the next president's been elected. She wanted to preserve the core of Roe. But it was part of her deep incrementalism and minimalism in not thinking the court should be moving too fast. So where are we now? And just to step back, once again, about the debate that's going on now. I said that Ronald Reagan in 1980 had promised to appoint originalist justices who had rolled back in the administrative state. And he just got his majority to do that. He almost got it in 1987 with the appointment of Robert Bork, but when Bork's nomination failed, he had to wait 20 years until the passing of Ruth Bader Ginsburg and the appointment of Justice Barrett for a supermajority to be ready to strike down the administrative state. Is this pure politics? No, it's not. Reagan promised to appoint Jeffersonian justices who would strictly construe the Constitution and limited federal power, and explicitly invoked Jefferson as a model, repudiating the vision of Alexander Hamilton, who thought that there should be broad national power to charter a bank, to respond to unexpected economic and social challenges, and the court should defer to that broad vision. That debate between Hamilton and Jefferson about the nature of federal power has defined all of our judicial battles during the four big eras of constitutional history. First, the founding. Second, Reconstruction. Third, the New Deal. And we're in the fourth era, the Reagan originalist Constitution, which is trying to resurrect those Jeffersonian visions, is what the pre-New Deal court tried to do in 1936. FDR won. He was able to appoint new justices. They embraced a more Hamiltonian version, and now we're back to Jefferson. RBG, it's clear where she would have been here. Her hero is John Marshall, and she believed that Marshall was right to uphold the bank and would fiercely reject the Jeffersonian vision. And she also would have thought that the judges shouldn't go too fast in changing the law, in striking stuff down, in getting too far ahead of politics. But I think she would have respected the fact that this has been a long historical battle. It's not pure partisan politics. It has to do with deep disagreements about the nature of the Constitution, which go back to the very beginning, and that is what we're seeing play out now.
Dahlia, Roman, would either of you like to weigh in? Maybe more specifically on the issue of race consciousness and what that might look like this term.
I'm not sure that there's a ton on the docket. I think there's a voting rights case. There might be, recently I think the big news was there was a voting rights case last term in which this is one of the most important cases of the term involving Alabama's districts and whether they had set up the districts to have sufficient sort of districts where you would protect the ability of black voters to elect representatives of their choice. The court essentially said Alabama needs to redraw the maps so that there are two black majority districts. Alabama didn't read the opinion quite that way, despite some language in the opinion appearing to say something quite like that. And so they decided they weren't going to do that. And the lower courts said no, you've got to follow what the Supreme Court said. And there was kind of a big moment in the last couple of weeks where Alabama tried to get the Supreme Court to come in, and they tried to make new arguments. And the court I think just a couple days ago, said no. And so the court said, no, we're not going to take that. No noted dissents. That was an important moment that touched on the race issues. More generally, I do think the kind of question of the colorblind constitution is very much on the agenda as the court looks at these issues. And I think the decision, the affirmative action cases, sort of enshrined a vision of what the Constitution has to say about race that really has been an important priority for the Chief Justice. Chief Justice Roberts, who famously said in a decision a decade or so ago that the way to stop discriminating on the basis of race is to stop, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. And the vision of the Constitution and the Equal Protection Clause that were embodied in the affirmative action decision is this vision of a colorblind Constitution that its supporters trace back to the abolitionists, to the drafters of the 14th Amendment, who in many cases were explicitly colorblind, to the dissent from Plessy versus Ferguson that Justice Harlan issued, where he said the Constitution is colorblind. And it was striking in the Chief Justice's opinion, his reliance on the arguments and the legal briefs that were made by the black school children challenging segregated schools in Brown versus Board of Education, where they embraced a similar concept. And obviously that's a very contested concept on the court. And you had very vigorous dissents from the more liberal side of the court disagreeing with that vision of the Constitution. But I think that tension is going to continue to play out. And the case that Jeff mentioned involving the Thomas Jefferson School in Virginia, I think is a very significant case that's going to sort of tease out exactly what the court thinks colorblindness means and what schools can do to promote diversity in ways that don't look at individual candidates and give them a sort of plus factor or a minus factor on the basis of race. And so we'll have to see how that shakes out.
I can do 3 very quick thoughts. I opened by talking about Rahimi, the gun case, and said that was a case where rather than take the win, you push the win. I think the Alabama case is rather than take the loss, you say you won. And you take it back to the court and you say, well, if you read Justice Kavanaugh's concurrence, it's pretty clear we're going to win when we bring it back to the court this year. And as Roman says, thankfully the court was like, yeah, no, we don't play that way. You take the loss and we'll let this percolate up. Either way, I think it suggests that we are in, as Jeff says, a really profoundly different moment with a 6-3 supermajority, where you have plaintiffs bringing cases to the court simply on the notion that we're going to win this go-round. Don't forget there's a carve-out in the affirmative action case that says, but not military academies. They have, we don't know why, we're just going to drop a footnote, best of luck, but military academies still have national security interests that go unspecified, and immediately we see a challenge, this last month, to military academies' use of affirmative action. So I think we're just in a very accelerated, things that used to take years to seed and to percolate up are being sort of mashed onto the court docket and sort of said, we think we've got the votes and we maybe should have started with this, but there is some benefit to having the median justice at the court be a Powell or an O'Connor or a Kennedy, simply because everybody playing pumps the brakes because nobody quite knows what's going to happen. And we are in this moment where we're just sort of on a rocket ship to the moon, where everybody has some sense that they have 5 votes in their pocket. How do they know that? Because they read a concurrence. And that's just, we're not used to that kind of pancake effect of doing justice. I just want to answer the part about the Redding case, because it was fun. I was in the court when, at that time, Justice O'Connor had just stepped down. Justice Ginsburg was the only woman. This strip search case was being treated, I think I talk about it a little bit in the book, but it was the source of like a kind of who's on first hilarity, where the male justices were like, ha ha ha, did they strip search her from the inside out or the outside in? And ha ha ha, how is this different from getting dressed for gym class? And there was this kind of like Porky's level of comedy that Justice Ginsburg, who never, ever lost her temper, was just on the bench, visibly dismayed that the strip searching of a teenage girl without calling her parents because she had ibuprofen on her was like just not a joking matter. And the reason it's important is she did a thing she never did, which is talk to a bunch of reporters while the case was pending. And the court, as you said, the outcome changed. The reason this is interesting to me in this question of when your life experience is coded as like enriching life experience and when it's coded as bias is, I think, the most fraught question that we are now living through, right? So when Justice Alito at his confirmation hearings talked about his family, coming over and being subject to all kinds of anti-Italian animus, that's seen as sort of like a layer of, sensitivity on top of objectivity. When Justice Sotomayor says famously, a wise Latina woman and a wise Latina man might, in the fullness of their experience, come to a different conclusion in a case involving those issues, that gets coded as bias, right? And then the questions that she's asked are you biased? So I just think we have to think really hard about who is neutral in this way. That goes to, I think, that the sort of beating heart of your question about how we think about race is who is neutral and who is biased and how we code that. And the very last thing I want to say, I know I said 3 things and I've said 7, but one of the most interesting things, I started covering the court a bajillion years ago, as you said, and when I started covering the court, Justices O'Connor and Ginsburg were the 2 women on the court. And there was this like very, very robust academic conversation about whether women do law differently. And like actual law review articles about how women think differently about the law. The data showed, aggregated over all the time they served together, you have 1 Republican appointee, 1 Democratic appointee. Unsurprisingly, about 50% of the time, they're in accord. Not a surprise at all. In cases that had to do with gender, discrimination, pay discrimination, and pregnancy, the accord goes up to 90% between the 2 of them. So that's not because they're biased. That's because, as you started your question, they had a different way of moving through the world as women that inflected on everything they decided. And so I think we all have to be a little bit more generous about who we impute bias to and who we impute objectivity to, because the truth of the matter is we are all of us enriched by having a court that looks like us. But more pointedly, I think that claims that people who don't look like us are biased is exactly sort of the poison that is seeping into the whole confirmation conversation.
Thank you. And let the record reflect that bajillion years was not my experience. One more question before we shift to more broader institutional themes. Jeff actually beat me to it. So Jeff, in your book, you recall how you asked the late Justice Ginsburg in one conversation and another about Brown versus Board of Education, and the quote, I have down, although I could be wrong, is this adage that the court is not supposed to reflect the weather of the day, but the climate of the era. The court is not supposed to reflect the weather of the day, but the climate of the era. Is today's court reflecting the weather of the day, or the climate of the era?
Depending what day it is and what era. If it's right that we're seeing a fundamental clash between Jeffersonian strict constructionists and Hamiltonian loose constructionists, between proponents of states' rights and national power, then what the justices are reflecting is not partisan politics in an effort to help Trump or Biden win, or not the 1800s versus today, but fundamentally different political philosophies whose clash dates from the time of the founding but persisted through now. And this gets to the hardest question in how to think about the court and the Constitution, which is it all politics? And when you see the 6-3 decisions, lots of people assume it's all politics. And students often assume it's all politics. And my students at the Constitution Center and at GW sometimes think that. There was an amazing moment during a Zoom class with middle school kids last year, the year before last, when Justice Breyer was talking, and some middle school kids basically asked, is it all politics? There were all these 5-4 decisions. Justice Breyer gave a fascinating answer. He said, it's not partisan politics at all. No justice would vote because they wanted to help one partisan politician or another, but it is political philosophy that a judge will rule differently if she is a libertarian or a socialist, a partisan of limited government or of broad government. Judges make rulings based on their broad visions of how government should work. And that subtle distinction helped me understand that it isn't all partisan politics, and it's also not all neutral methodologies that invariably command results regardless of their consequences. There's a reason that a limited government libertarian would embrace a Jeffersonian form of strict constructionism, because the results line up in terms of how broadly government power is. And the same for progressives who, ever since the progressive era, as Herbert Crowley said, began embracing Hamiltonian means for Jeffersonian ends, broad visions of governmental power in order to achieve economic equality and liberty. So then we're seeing this fundamental clash of political philosophies played out as a fundamental clash of methodologies. And it's taking place on the court, but as Dahlia said, it's happening really fast. And the Jeffersonians are moving fast. And Justice Sotomayor said, this is a majority in a hurry. Why so fast? Why do you have to overturn all these precedents so quickly? What about respect for stability and institutional legitimacy? And that was the big decision at the core of Dobbs. And you could think Dobbs was wrong, as Chief Justice Roberts did, but also think that the institutional legitimacy of the court was crucially important. And Chief Justice Roberts, when he came to office in 2006, said he thought it was urgently important in this polarized age when citizens mistrusted the courts and all institutions as partisan bodies for judges to embrace narrow, unanimous decisions that all sides could embrace. And he said he was going to make it his model as Chief Justice to persuade the court to avoid broad constitutional rulings, to come up with unanimous rulings, and to maintain legitimacy. Now, I think it was a noble effort, and he tried and he had some success, and his model was Marshall, and he understood what a perilous time we're in, but then he lost the votes. And it was so poignant to see his concurrence in Dobbs. He would have come up with a response that moved more slowly, upheld a 16-week limit, but didn't overturn Roe, left the other questions to the future, as Justice Ginsburg would have done. Not ideal for Justice Ginsburg wouldn't have agreed with that, but that's an institutionally minded, go slow, I care about the legitimacy of the court vision, which is a very powerful vision dating back to John Marshall. But there are not six votes for that. So he is now required to watch as the majority moves much more quickly. And now the question is how much more quickly. And Dobbs Roe is gone, and the affirmative action case is gone, and the other big question now is the administrative state. Now, who knows, but because Justice Kavanaugh, at least, if not Justice Barrett, is with the chief in this regard, they're unlikely to go so far as to strike down the whole administrative state. And maybe there'll be a split between the textualists and the traditionalists again. But to get back to, was Paul Freund right to say that the court should move more slowly? The New Deal justices the pre-New Deal justices who were trying to strike down the administrative state didn't think so. And I guess critics of the Warren Court would say that they didn't go so slow either in expanding equality and so forth. It's a matter of votes and interpretation. But so what that suggests is what's important is not only are you basically a Jeffersonian or a Hamiltonian, but how much do you care about legitimacy and going slow? And maybe just to wrap up this thought, these are extraordinarily serious times for the rule of law. And the partisanship of our country suggests that not since the election of 1800 and possibly the Civil War have we seen such a grave possibility that the institutions are going to fail. And the possibility of a breakdown and even violence surrounding the next election has not been so grave since the 1860s, right before the Civil War. And that's why it's so, and the court's going to be at the center of it. And it may decide the 14th Amendment, Section 3 cases, and it could decide presidential self-pardon cases. And suddenly Chief Justice Roberts'
think I agree with a lot of what Jeff just said. I do think that, and when certainly true, we're seeing a lot of change in the law with the newer justices appointed by President Trump joining and creating a majority that wasn't there before. At the same time, though, I think that there was inevitably going to be change, and there was inevitably going to be, changes to precedent, regardless of how, if Hillary Clinton had won the presidential election, if we just sort of reverse in time and imagine that world that a lot of us probably thought was going to happen with our political prognostication hats on, I think you would have seen a lot of very similar doctrinal shifts. Already when Justice Scalia passed away, you saw some prominent law professors with glee, not at Scalia's passing, but with glee at the prospect that there was going to be a sort of permanent, long-time liberal majority on the court, and the list of precedents that would be on the chopping block were being put out there. I think even with the change, even when you had Justice Kennedy on the court before some of these changes happened, you saw, I think, the left side of the court, which no longer is in the driver's seat now, but they were able to make very significant gains. And if you look at the achievements from a progressive perspective, what the court has done, I think the most significant thing probably over the last decade or two is the expansion of LGBT rights. But we shouldn't forget that that expansion of rights came by overturning a series of very significant precedents. The Bowers versus Hardwick case, Baker versus Nelson, which said that marriage, that gay marriage was not a right. And so I don't think it's right to think about sort of one side of the court being more about incrementalism, and the other side of the court being this sort of conservative majority that just wants to go quickly. I frankly think that where you stand sometimes depends on where you sit and how many other votes you have. And I think that it's just a feature of the fact that you have this sort of randomness in when the judicial appointments come open, when new justices come on the court, and then when justices are there, they tend to vote in accordance with their convictions. And sometimes that means change, and sometimes change comes more quickly than some might like.
Yeah, and actually that's a point that I want to actually shift toward. Now that we've talked about some of the court's cases and some of the competing views about the ways that politics maybe overlaps or doesn't overlap those cases, let's talk about the political institution of the court. And clearly, as Roman alluded to, the 2016 election did not go a way that some folks wanted. There was Mitch McConnell's refusal to have a confirmation vote on Merrick Garland months before that election. There was the confirmation of Justice Amy Coney Barrett months before the 2020 election. There, of course, have been, as some of you have seen in the news, there, of course, have been the ethics disclosures around Justice Thomas, and of course, there have been other ethics disclosures in the past. And there have been calls for term limits, putting more justices on the court. I'm sure that would be a whole other panel. But the question I want to ask is, and maybe I'll start with you, Dahlia. Given all of this, do you think it's time we start talking about the court like the Congress, like Congress and the White House? Do we need to start talking about the court like a political institution, or does that do a disservice to some of the arguments that it's not just politics?
I mean, the court is a political institution by design. It was constructed to be one. Its members are appointed by a political president and confirmed by a political Senate. So the idea, all due respect, that this is a political process that simply grinds to a halt the day that a justice is sworn in and says that he's an umpire. I mean, I suppose that if you believe in like unicorns and fairies and rainbows, that works. And that, by the way, is a systemic, self-definition that the court has given us, right? Whether it's umpires or, Justice Thomas's construction, we're like runners, we strip down, there's nothing left except, we're just here as minds and bats, interpreting the Constitution as oracles, and I think that is very much a posture that serves the court, right? Neither the purse nor the sword, that's the Federalist Papers. What do you have? Public legitimacy. How do you sustain public legitimacy? You devote an immense amount of time and effort to constructing a building that looks like a Roman temple, to wearing black robes, to having for years and years and years on the transcript, it didn't say what justice was asking the question, it just said the court, because they're all the same, because they're brains and bats, and once they're sworn in, they become umpires, right? And you know who colluded with that story? We in the press corps. we told the story, and I joke about this, but it's not untrue. We every day go into oral argument and cover oral arguments as though, the justices are dead and the dormant commerce clause is alive. And we write about that. We go into the press office and we're like, oh my God, did you see what happened to Chevron today? And we don't care about what any of the justices did or said or who they traveled with or who was making donations to the Supreme Court Historical Society in order to go to the Christmas party and talk to, that was not our beat. And unfortunately, we have learned from our friends at ProPublica and at Politico and at The Guardian and at all the newspapers who now seem to have a devoted Supreme Court as politics reporter that we were, with all due respect to my colleagues, asleep. We were just asleep at the switch because we were very busy covering doctrine and not the institution. So I am the wrong person to ask. A, because I am full of shame and self-loathing, that I was a party to this oracular view of how we cover the institution, but also because I think we have aided and abetted a project that now results in justices who don't like press scrutiny, who don't like being told, hey, maybe you should have disclosed the private jets and the glacier martinis and the salmon fishing trip and the fact that you were at a Coke event where high donors got to be in the room with you and they have a case on the docket, and now they're mad at the press. They see that as an attack on the integrity of the court. And my view is, and here I completely agree with Roman, that those of us who are worried that the 2024 election is going to be decided by the court, those of us who need to live in a world where the rule of law is determinative because, and Anita Hill says this in my book, the alternative is violence. The alternative is street fighting. It's what we're seeing around the world when the rule of law disappears. And that's when vulnerable minorities lose. And so for all of us, I think on this panel, who might have different criticisms of the court, it does not come from a place of we want to tear down the court. We want it to be a smoldering ash heap with no legitimacy. Anyone who lives in a constitutional democracy knows that we are only as strong as the public's willing to accede to and abide by rulings of the court. But when the court is behaving in a fashion that calls into question whether they are brains in vats, and that was the deal. You pretend you're brains in vats and you act that way, and we will agree that your decisions are lawful. That's not on the press. That's not on the public. That's not on folks in Congress. That is not on the academics who are writing about this. That is on the court itself. And so my feeling is, of course, we should cover the court the way we cover any other partisan political branch of government, because the alternative is to just wish cast and call it journalism.
I think I agree with a lot of that. In terms of the overarching point about the importance of covering the court fairly and fully. On the other hand, I also think that it's important for journalists and people writing and thinking about the court to also be nuanced and balanced in the way they present the issues. And it seems to me that the ideal of judges or justices as umpires is a very real ideal that I think all 9 of them basically, actually in real life subscribe to. I don't think it's unicorns and fairies and rainbows. I think it's an ideal that is hard to live up to and that they have to call themselves on and that they have to call each other on. But I think that it is real. And I think that's why you can have a world in which the justices are deciding cases that are not 6-3 every single time. And they can decide things like, when the most partisan thing you can possibly imagine, a presidential election comes up, and the President of the United States, who has appointed 3 justices to the court, and saying when he's appointing them, in part, we need to get Justice Barrett on the court because we're about to have an election, and I might need some help. And what does the Supreme Court do? Echoing the actions of lower court judges of all ideological stripes, they basically say no. We're not getting involved in this. When the subpoena cases come up, the court says no. When Obamacare comes up for review, you have a majority of the conservative-leaning justices upholding Obamacare in the most recent of the cases. So over and over again, you see cases that are not explicable if you think of the justices just as political actors that are analogous directly to members of Congress. And so I think that it's true journalists do have to cover the court with skepticism the way that you need to cover all public institutions with skepticism. But I also think, to be fair to the justices, it's important to take seriously what they're doing and to recognize that what they're doing is not simply imposing their policy preferences in the way that it would be perfectly legitimate for them to impose their policy preferences if they were members of Congress or the President of the United States.
So at the beginning of every Constitution Center program, I recite the mission statement that comes from Congress. And I mentioned it. The only institution in America chartered by Congress to increase awareness and understanding of the U.S. Constitution on a nonpartisan basis. So what does it mean to urge citizens of all ages to think about the Constitution on a nonpartisan basis? And should they actually see the court as political actors? And as I suggested to you, I don't think it's accurate to see the court as political actors, because as Justice Breyer said, they're motivated by political philosophy, not partisan politics. And the election cases are a very important example. 70 judges or some such, 60 considered election fraud cases, and all of them said no. They rejected it. They said there's no election fraud. And one of the many judges who ruled that way was Stephanos Bibos on the Third Circuit, who rejected the case in Pennsylvania, and when he talked about it at the Constitution Center, he said, the president's not my boss, the Constitution's my boss. There was not even a hint that what could happen here is what happens in Putin's Russia, where Putin calls up a judge and tells him which way to vote or kills him. That doesn't happen in America because the rule of law in these important cases works. So should journalists cover the ethics stuff? Of course, journalists should do whatever they want. It's a free country, and obviously people should write about whatever they like. But should you, as readers, draw the conclusion that if Justice Thomas goes and spends time with Harlan Crow and doesn't disclose it, he's voting the way he does in a case that helps Harlan Crow because Harlan Crow gave him a plane ride? No, that's not the way it works. He's voting for a conservative interest there because it's consistent with his conservative political philosophy. And in that sense, it's too simple to suggest that justices' votes can be bought. Now, that's not in any way to defend the conduct of not disclosing these trips or to suggest it doesn't call the court into grave questions. Judges should behave like monks or rabbis. Obviously, here it's rabbis. They should be beyond any possibility of question. Their behavior should be irreproachable, and and as Justice Kagan and Justice Kavanaugh recently known, the court knows that it needs an ethics code, and they're eager to find one, and they're having trouble agreeing on one, probably because they don't want lower court judges telling them when to accuse. But of course, the court should have an ethics code, and of course, the judges should not even get close to violating it. But that's not to suggest that we should see the court as purely political actors, because it's a complicated mix of politics and law. It's constitutional politics. It's political philosophy. The interests often align, as that Hamilton-Jefferson divide shows, but they're not driven to help individuals on the basis of politics. And I face this with my students too, and they say, they ask the same question: is Justice Thomas voting for Harlan Crow because he travels with him? And I would say what I just said to you, and now I'll say that journalists, of course, should do what they like, and everyone should cover every aspect that they please, but you have a responsibility as citizens trying to figure out what to think about the court, to read the decisions and educate yourself about what they're actually saying. And the only way to do that is to read the majority opinions and read the dissents and make up your own mind. And when you read a case like Bruin and think that the conservatives are playing fast and loose with history, you can conclude they're overcome by their passionate philosophical desire for citizens to defend themselves against big government or whatever, and are violating their methodology. That's fine. But don't assume they're voting that way because the gun lobby is paying them, because they're not. And that takes time, and you've got to educate yourself the way you are listening to this riveting but long These arguments are complicated, and it takes all of us a while to explain them, but that's what's exciting about the Constitution. And in the end, that is what is, if anything will save us, as we all, I know, pray that it will, moving up to 2024, it will be this glorious system of constitutional debate. I just learned this recently, because I looked it up. Constitution, come stituare, together, come together, stand together is the Latin. A constitution is a platform for resolving disagreements peaceably. It's a structure for people listening to each other and peaceably deliberating and resolving their differences. And it's the glory of America. It has structured our disagreements so far. It only broke down once in the Civil War. And let us pray that it's not going to happen again.
Speaking of citizen engagement, this is an excellent time to transition to a few minutes for questions. So Lisa and Haley have mics. Go ahead and raise your hands. In the interest of getting in questions, I may cut you off. I may rephrase a question. Please don't be offended. But we'll try to get into a few questions before turning to the panelists for some concluding remarks. So over here, and then the gentleman over there.
When we hear Jeff Rosen talking about the potential of civil war, and we hear about the Supreme Court and its supporters pushing toward extremes in areas like gun control and abortion, it leads me to ask a question I've never heard discussed, which is, doesn't the Constitution itself contain an escape clause called amendments? Is there anything to think in terms of the dynamic of an amendment process being a way out of any of this, or is the amendment clause itself no longer a part of the practical Constitution?
For such a great question, and of course this was the hope of the founders, that our changes would be resolved through amendments. Jefferson would have gone even further and had a convention every 19 years, because he said that the earth belongs in usufruct to the living, the dead can't bind the living, and you've got to go back to we the people every 19 years to see if they still support the Constitution. It's a radical.
I don't think that would have worked.
And Madison said it wouldn't have worked, and he said no. It was a miracle that the first convention worked. If we have a second one, all these anti-federalists are going to try to break up the union with these specious demagogic arguments. Don't risk it. But the amendment process is the compromise. Now, there's some. Joe Lepore says it's impossible to get an amendment through now because you need 2/3 of Congress proposing, and given the red-blue divide, they can't agree on anything, and 3/4 to ratify, and therefore in practice, the main mechanism that the founders thought would change stuff has become impossible. And just to give one example, it's amazing that in 1973, Birch-Bayh proposed an amendment that would have eliminated the Electoral College and had a national popular vote, and there was overwhelming national support for it. President Nixon and the Democrats all supported it because it hadn't been polarized. If it had been proposed, it would have been ratified in months, and 3 Southern Democrats stopped it because they wanted to preserve Southern power in the Senate. We would have had a national popular vote. It shows the contingencies and also how much the polarization has made it impossible to propose amendments. One quick note of hope here. We had an amazing virtual constitutional convention at the NCC where we brought together 3 teams of leading liberal, conservative, and libertarian scholars. And in a week, I watched this on Zoom. It was like watching the founders. They agreed on 5 constitutional amendments. And here they were briefly, term limits for Supreme Court justices, making amendments a little easier, making impeachment a little bit harder in the House and easier to convict in the Senate, eliminating the natural-born citizenship requirement for president, and resurrecting a legislative veto, which would allow Congress to repudiate executive stuff it doesn't like by majority vote, which it was able to do before the Supreme Court said it couldn't in 1980. What's so striking about that is it suggests to me there's broader consensus on constitutional issues, at least among people who think about this stuff, than partisan politics would indicate. If those amendments were actually proposed, they might be ratified by the states, but they won't be proposed just because of the polarization in Congress. So that is a Madisonian challenge. The main mechanism for change, as you say, Bert, the founders conceived of wasn't the Supreme Court changing the law fast, it was amendments, and now because of polarization, we can't approve amendments.
We'll take 3 or 4. I'm sorry.
Hi, good evening. I believe you had mentioned term limits for the Supreme Court justices. I'm just wondering if you think that term limits are a good idea for future implementation for the Supreme Court, and if so, how long should those term limits be?
This is very fascinating. We should turn it over. Our team proposed 18-year term limits, which is often agreed on. And what's amazing is the justices themselves endorsed it. Justice Breyer said it would be fine as long as it doesn't apply to him. And so have Justice Gorsuch too. So if Congress proposed it, the court would go for it. But could it be proposed, or is there some?
No, I associate myself with my colleagues spitballing. I think 18 years makes sense, and I think it depolarizes and decrazifies the confirmation process and the entire, the possibility that every president has the same number of appointments, and that you can't time your appointment or death, for cynical purposes. I think all of that, as one does. So I think I am a big supporter of the 18-year term limit.
I think the challenge is that it really would need an amendment, right? And as Jeff was saying, an amendment is very hard to get. And so I think as we think through as citizens, where are we going to put our time and effort to try to move the needle on some of this stuff? It just seems like, even if I'm not persuaded that a term limit would be a good idea, if it were 18 years, I could probably go along with that because that's a very long time. And so preserves kind of the independence that I think life tenure currently preserves. But I think realistically, it seems very hard to achieve. I don't think you could do it just by passing a law, by legislation. I think one just general comment about some of these reforms. I think to be very serious about, thinking seriously about the kinds of reforms you could make by statute or otherwise, and I think this is true of the ethics stuff too, the worst thing that can happen is to have these sort of structural reforms be injected or proposed or put forward in a political way. Because as soon as that happens, then you kind of have the normal dividing lines come up. And so I think to the extent that there are some proposals, I think the 18-year term limit was at some point endorsed by someone like Ted Cruz, I think, was on the record on this. So this is the kind of idea that in theory could get broad-based support. But I think broad-based support is important and necessary for any kind of structural change to be to actually, whether it's a constitutional amendment or a statute, to get put into effect.
Can I just add one parenthetical? This goes to my self-face punch analysis from earlier. I mean, when you learned that the justices started doing financial disclosure, post-Watergate on their own steam, they just looked at each other and said, here's the thing we're going to do now. We're going to do disclosures. They didn't do it till then. When Abe Fortas, for a much lesser offense than some of the stuff that we're hearing now, took money to give a lecture series at American University and cavorted with somebody who was a sketchy financier, the court pushed him off. The justices pushed him off and said, for the integrity and the esteem of the court, you have to go. So I think sort of part of my response to this argument of do not impose it extrinsically because it delegitimizes the court is that the court, when it is at its best, legitimizes itself. And the choice not to sort of level up in moments of controversy and in moments of ethics scandals, I think is a choice. And moreover, I think to say you're coming after us because you don't like us is a choice to turn it into this binary of it's being forced on us by Congress or it's being forced on us by this blue ribbon panel, that made a bunch of suggestions. And I think the real curative here, and this I think we all agree, is for the court to say we have to hold ourselves to the highest possible standards, including, by the way, the appearance of impropriety, not my feelings about my impropriety. And so I think that we've seen the court rejigger its own conduct in response to public outcries post-Watergate and again, pre-Watergate. So it's not as though the court can't impose upon itself these requirements. We're just at a very, very mystifying moment where the more the sort of pressure ratchets up, the more we hear from the court that this is an effort to delegitimize the court.
I'll take one more question and then I want to turn to our panelists. I'll let Lisa pick. No pressure.
Smart move.
That's what I'm here for. Thank you. And thank you for a fascinating discussion. One topic that hasn't come up is national security. And huge topic, obviously, but I'm wondering how you all think about two of the sort of big themes that you've talked about. One, in terms of the court moving really fast, and traditionally the court doesn't want to get involved in national security. It's like, no, not us. But also in terms of your sort of competing visions, I don't know how well that necessarily tracks, especially when national security is often about separation of powers, so not about the relationship necessarily between the federal government and the people. But so I'm just wondering how that plays out in some of these themes. Thank you.
It's so great. Well, Hamilton has to, and national security has to be the Hamilton side, which was his two goals are order and security and broad power to enforce it. And the Jeffersonian libertarians don't like it. And during the 9/11 cases, there was an interesting coalition of civil libertarian liberals and libertarian conservatives in opposing parts of the Patriot Act and even striking some of it down under the Fourth Amendment. And those cases have been dormant. And of course, now it doesn't matter whether Dems or Republicans are in office, they always move to reauthorize the authorities and broaden them, of course. And the court, which, as you know, tends to defer. And all this is to say that it would be great to have to see if there was a kind of libertarian, civil libertarian pushback, but there hasn't been so far. So
Yeah, I think there's interesting echoes on the, when I was sort of coming of age as a law student, it was sort of in the wake of the 9/11 cases, where for about a decade, that was like a huge hot topic, and that sort of petered off. But I actually think the COVID phenomenon sort of raises a very interesting set of issues about sort of government emergency powers. And, we saw it with respect to, closure orders that impinged on religious liberty, vaccine mandates that sort of infringe where people could go and how they sort of like carry themselves in ordinary life. There's some First Amendment issues implicated there too. Student loans is sort of a COVID case in the sense that the emergency powers for the student loan initiative was under COVID. And so I kind of think that this sort of major event that we've gone through over the last few years has given rise to a similar set of challenges and issues that the 9/11 cases did. I don't know when the next national security sort of window will be for that to be hot at the court, but it's going to come because inevitably there'll be a conflict abroad, a terrorist attack, some sort of other biohazard threat. Who knows? But I think you raised an interesting question, and I don't know how this group of justices will sort of approach that particular issue.
Since we're nearing the end of our time, I'm going to take moderator's privilege and combine some questions and end on this note. So Dahlia, you have a line in your toward the end of your book that, and I swear she didn't pay me to say this, but I actually can't get this line out of my head. Toward the end of your book, you talk about Stacey Abrams' decision not to contest the results of the 2018 gubernatorial race. And you write this line that says, "The law is for citizens, not lawyers." The law is for citizens, not lawyers. And so as we wrap up our time tonight, I'm wondering if each of you could take a moment to share, first, what does that mean to you generally in the context of our conversation about citizenship and engagement with the courts? And what's one piece of advice you have for folks here, lawyers, non-lawyers? What's one piece of advice you have about a resource to follow, something to do to stay engaged in the work of the Supreme Court and of appellate and other courts across the country? No pressure.
I guess I'll start. I mean, I think that I'm gonna cheat and endorse what Jeff was saying earlier. I think it's really important for citizens to be educated, to educate themselves, and especially in a climate where we get our information from whether it's our phones and social media, or from websites, or from TV. Everything's so polarized. I think it's especially important to read widely and be exposed to different views. And hopefully to conversations like this one, where we all have slightly different perspectives, but are engaging in good faith on hard issues and exchanging views. So I think that's really important for citizens. I think reading the opinions is very valuable, and reading a lot of the great coverage from both the right and the left and the center on the court. I think that is all sort of what I would recommend. The only other thing I would say is that having on good authority that Jeff's institution is a phenomenal institution to learn about and study the Constitution, and I'm very happy to be taking my own advice. We're taking our kids to your museum on Friday. We're very excited. So all of us, maybe we should all take a field trip there. We can all engage on all this this stuff. So that's my advice, mostly stolen from Jeff.
Now that Roman's got that out of the way, no promoting your own resources.
We're happy to send a discount, by the way.
I'll promote them a little more than Dahlia. I'm so glad you're going to the MCC. The physical space is just so inspiring. It's this temple to the Constitution on Independence Mall, across from Independence Hall. We just put in the main atrium the words of the First Amendment. Remember the old First Amendment tablet at the museum?
Yeah.
We took it down brick by brick. I carried it on I-95, reassembled it at the Constitution Center, and imagine 70 feet high, the words of the First Amendment shimmering in this space overlooking Independence Hall. It just blows your mind how exciting it is to be physically there. And then there's exhibits for kids, the framers, a new First Amendment exhibit. It's just constitutional heaven, so you've got to come. But far more than that, if you can't come, you must go to the website and educate yourself with these unbelievable resources. Imagine what a privilege it is, because I've got the best constitutional gentleman in the world, to be able to moderate these podcasts and Zoom programs and conversations and classes that actually bring together people of different perspectives, liberals and conservatives, for these civil, thoughtful dialogues. And you just can't have a conversation like the ones we've been having with people of different points of view about the Constitution, where you take some time and not come off with optimism about the possibility for disagreeing without being disagreeable, for exploring and resolving differences peaceably. You just learn so much, and you are so illuminated and educated. So check it out, and just finally to give you a sense of the depth of the resources, we assembled the top liberal and conservative scholars to write about every clause of the Constitution, describing what they agree about and disagree about. So you can look at Amy Coney Barrett and Neil Katyal with 1,000 words about what they agree the habeas corpus clause means, and then separate statements about what they disagree, and multiply that by 80 clauses. It's just a constitutional feast. It's so exciting. It's a lifetime learning, and you have not only the opportunity, but you have a duty, you have a responsibility as citizens, and to inspire your kids, so that we can all be guided by reason rather than passion, and unite around the shared values of the U.S.
Pile on. I was telling Roman before we started that when my younger son was in 5th grade, I did a trip to Philadelphia from Charlottesville, and came home and was like, I went to the best place. And I was like, what did you see? And he described going to the Constitution Center, and I was like, you know, that's my job, right? That is the work I actually get paid to do. And he was like, no, but this was not that. This was really cool and interesting. So like, more kudos to Jeff for building like a really important building. I think I want to say 2 quick things in response to your question, because apparently I can never confine myself to one. One is, you asked about the meaning of engaging with democracy, and I set out to write a book about women and law and the rule of law, and a bunch of what I thought were seminal cases during the Trump era. And the second half of the book is about voting and voting rights and gerrymandering and redistricting. And there's like literally an entire chapter that is about one person, one vote, because voting is everything. Because you can't have the law and the rule of law in a democracy if you can't vote. And so it ultimately, Don't Tell, is a book about voting much more than a book about law and constitution. The other thing I want to say, and this I actually feel like I can only say in the Capitol Jewish Museum, and Jeff has heard me tell this story 2,000 times, because we did a tour after RBG died where we were on multiple Zooms together talking about Justice Ginsburg's legacy. And I think like there's a teaching in the fact that Justice Ginsburg got super famous for doing the thing where instead of bringing a case with a female plaintiff, she always found the guy, right? And she challenges rule after rule after rule that is sex discriminatory, but she finds a guy, and it's described always as like a party trick. Like, look how smart she was, she had a panel of 3 male judges, they were never gonna find sex discrimination if it was a female plaintiff, but it's like some poor guy, who's a widower, who's trying to take care of his kid. They get that, right? I hate the party trick story about RBG. It was not a party trick. Jeff will tell you, I will tell you, anyone who ever interviewed her would tell you that she genuinely believed not that you were tricking men into subordinate positions, but that we would live in a better, more just, more fair, dignified world if men could stay home and take care of their children, if men could stay home and take care of their ailing mothers. In other words, this was not a this was a lift us all up, because until and unless men are free to move about the world with the full range of emotional and caring and dignitary, interests and privileges that women have, we are not free. And I tell you this because I love it as a piece of, forgive me, Torah, a biblical teaching, which is that we have to stop the zero-sum thing, where every time anyone gets a thing, we lose. And what scares me is this scarcity mentality that animates the affirmative action cases. If someone else's kid gets into Harvard, my kid loses. The Indian Child Welfare Act case that says if a Native American tribe gets to adopt their own children, I lose. If Alabama creates a second district reflective of the population, of the Black population in that state, I lose. I am imploring you to take the lesson of RBG, which is a lesson of if we live in a place of scarcity in constitutional law, we will all lose. I am imploring you to think of what she did, not for women in her storied career at the ACLU, but what she did for men. And I am imploring you to think in terms not of scarcity of what we can't have because someone else took it, but what we can all have because we are freer if we all have everything. Think about the Constitution and the law through the lens that Jeff gives you, through the lens that Roman gives you, but also through the lens of RBG, which is there is too much dignity and grace and beauty in this country to be fighting over it.
So before I turn it over to the museum staff, let me say thank you so much to Roman, Jeff, and Dahlia. It's been a wonderful conversation.
Amazing and wonderful. I think we all have our own research and learning to continue doing as inspired by tonight. And Dahlia, thank you for those ending words. That was really beautiful. So I am going to bring Dahlia and Jeff over to this table over here. They're going to sign books, which you can purchase in our gift shop over there. And thank you all for a wonderful conversation tonight. It was wonderful.